Good morning, Ms. Smart.
Morning, morning.
How are you?
I'm very well, thank you, and actually much less nervous than I thought I could be. Flies, so yes, thank you.
No, you need not be nervous. We don't bite. Are you ready to start?
I'm ready, thank you.
Okay. Your CV tells us that you worked mainly in the hospitality industry from 1978 until 1996, when you went to the bar, doing
Yes.
various things, exciting things such as waiting tables and so on. But I noticed that you obtained your legal qualifications around that time. So were you studying part-time? Well, at least did you do the first, the BA part-time?
Yes, that was through UNISA, part-time.
Mm-hmm. And then you went to the University of Natal thereafter to do your LLB?
Yes, a 3-year LLB.
Mm-hmm. And a while later, you obtained the postgrad diploma in environmental law. Did you put yourself through university? That's the impression I get.
Yes, I did, yes.
Oh, that's commendable. So you joined the bar in 1996, the Durban bar, that is?
That was the end of 1996, yes.
Mm-hmm. And that's where you still are?
Correct.
What kind of work have you done? I mean, in how many years?
I think it's about 27 years. A variety. In the beginning, obviously, we had we were in the fortunate position to be allocated pro deo, so we cut our teeth at that early stage on court work and criminal work, and then after that it was just general litigation, whatever came along, and in the last few years, primarily corporate law and solvency matters, and recently in land claims court, which I quite enjoyed.
Yes. Well, your experience is not unique. I think you speak for all of us, especially the women who started practicing around that time. Were it not for the pro deo system, some of us would not have made it at the bar. So that kept us going until one could get work, and you could not be picky. You took whatever scraps were there for you. So I fully understand where you have been. You started acting in the High Court when?
I had one stint in 2019, and then nothing until last year from July, and then periodically since then, a total of 28 weeks.
28 weeks.
Including the 2019 session.
All right. And you sat in both the civil and criminal courts?
I sat in the criminal court for one session, but during the civil sessions, there were quite a few criminal appeals that I dealt with.
Yeah. Did you do any civil cases?
Civil cases, yes.
Yes, all right. Did you write any judgments?
Yes.
How many?
I think in total, which were reserved, were about 8. But a lot of the judgments, most of the other judgments were ex-temp.
All right. Any of your judgments reported?
No.
All right. Any taken on appeal?
No, not that I'm aware of.
No.
And, well, nothing up until now.
The professional bodies have, as you would know, have written in about your performance in the division. And the African Transformation
Advocates for Transformation.
Advocates for Transformation speaks highly of you, and they claim, they proudly claim you as their only white member who has done good things there, mentoring black juniors and so on, and they support your candidature. But the GCB has expressed concern about the period of time you take in delivering judgments. I will not take that any further with you. I'll leave it to the JP to probe further. But
I'm sure that's the big elephant in the room that will be discussed quite.
Yeah, you'll
quite
have
a
an
bit.
opportunity.
I recognise that. Thank you.
Okay.
Thank
All
you,
right.
Vice Chair.
Okay. I'm going to ask the commissioners to put questions to you if there are any, and the JP of the division will go first.
Thank you to CJ. Good morning, Ms. Smart.
Morning, JP.
Yes. In the 28 weeks that you have acted, how many weeks have you done in Durban? Do you recall?
Well, if I know that I've done about 9 weeks in Pietermaritzburg, so it would have been the difference between that. So it's probably 19 weeks.
Have you found
17 weeks?
Have you found any difference between the two divisions?
Not really in terms of workload. What I have found is that, well, when I practiced, Pietermaritzburg division has certainly become almost as busy as the Durban court.
Yes. And I see that you've done only one crime
Yes.
stint. Do you know why that is so?
I haven't, no reason. I haven't been asked to act
Allocated.
again. Yes.
Yes. Now, in that crime session that you have done, I am told, and I think it's something within your knowledge, that you took a few days to write a judgment and you refused to start a new trial. That is what the DPP's office reported to me.
During that session, I don't know if you recall, there was a problem with the lifts. So there was about 4 or 5 days where we couldn't sit. So that then took us up to the end of that session. The reason I was reluctant to take on a new case after that is because I didn't want to sit with a reserved judgment.
Yes, but
with an unfinished judgment.
yes, but you lost in it. That was my understanding is that the fact that the lifts were not working was a couple of days and more days because you were busy with your judgment and you couldn't start a new matter.
Yeah, well,
And a senior criminal judge had to speak to you about
yes,
that.
yes.
Yeah.
But that was before, that was at the beginning of the session, and I accepted that I would have had to have taken on another criminal trial, but it just so happened that we seem to have run out of days.
Yes, that concerned me a lot because we've got a backlog in criminal matters. And, judges, as they do often, will take a day only to deal with criminal judgments, or you simply adjourn and deal with it over the weekend. Now, when you lose about 4 days only for the judgment, then you have the system, the infrastructure issues, then it added more. So we could have probably finished another criminal trial there.
Yes.
Yeah. Now, the reserve judgments, which you said it is indeed a big issue for me. I've received a spreadsheet from the researchers. The one matter that concerns me in particular is K. Swindon. It's a civil trial which you completed in December 2022, and have you handed down the judgment?
That was handed down this week, yes.
This week?
Yes.
So that's about, 9 months?
10
or 10?
months, yes.
Yes. Now, if you take that long as an acting judge to hand down a judgment, And that is not the only one. The other one that I'm concerned about, MI Zulu and others versus the Provincial Executive Committee of the ANC, the African National Congress, KwaZulu-Natal. There you took 7 months to hand down the judgment. And then in another one, and I think I had to write to you with this one, for Nene versus Minister of Safety, you took 6 months. There's another one you took 6 months, another one you took 5 months.
Yes.
How are we going to cope afterwards if you take that long as an acting judge?
JP, it's a lesson that I've now learned. It's a hard lesson. The longer you reserve a judgment, the worse it becomes. It does, it become difficult to get back into it. In my last session, I did have 2 days where I had appeals, and in both those cases where I was a scribe, those judgments did come out within a week or 2. And other than that, I haven't reserved judgments. So it was the Nene judgment. It was a trial that was allocated at the beginning of my Pietermaritzburg session, and after that it was a non-stop. I couldn't get around to doing anything, and then getting back into practice, trying to keep up with or catch up with work. But it is something that affected me a lot during that time. It unfortunately didn't push me hard enough to finish it, but it was very much a kind of psychological block almost. But I certainly think that it's a lesson that I have learned and hope not to repeat it.
It's a concern because we're not talking about 1, 2, 3. We're talking about more than 3.
Yes.
And I regard you as a seasoned practitioner. You've been around for more than 20 or 25 years in practice. Why is it taking you so long to write the judgment?
JP, I don't know whether
because let me just tell you, the one for Nene, for instance, Minister of Safety, would have been probably an unlawful arrest.
Yes.
So why would it take 6 months?
JP, in that case particularly, I was quite torn between finding for the plaintiff, and I really had to. It seemed as if what I wanted to do was find for the plaintiff, and it took me quite a while to sort of do enough research and look at the evidence again, rewrite it when I was sort of almost absolutely convinced that there was no case in favour of the plaintiff. So I think it may have a lot to do with probably too pedantic. I think too much. I reflect too much about a matter. I really want it to be right, and perhaps that's a fault that I have.
So you battle to make a decision?
I think in short, probably yes.
Yes. Now, just 1 or 2 other things in the judgments that you have attached. The one that I think you were sitting with Stein J. It's a full bench appeal. It also raised the issue. The court, Meremoto, raised the issue of the Section 9310, which was not complied with.
That was in 20. Was that the recent one? Is that the?
It's a May 2019 case, yes. And I'm referring to page 29. What I want to know is, because it was not raised as a ground of appeal or in the heads, did you give the state notice that this is an issue that you want to raise so that they could prepare?
I don't recall whether there was any formal notice given to them, but I do recall that was when that was the first time I was made aware of Section 93, and I recall it was a big discussion that I had with Judge Stein.
Yes. And then you concluded that once you had dealt with that point, that the appeal must be upheld, but you still went further and discussed the merits of the matter. Shouldn't that have been the end of the matter?
I'd always believe that if there is a point which it would be dispositive of a matter in an appeal situation or in any trial, if you can deal with the merits in the event that it does go for a further appeal, that the appeal court would have an understanding of what the court au quo had on the merits.
And then finally, is there a reason why you haven't attached a judgment in the criminal matter?
Because that was an extempore judgment, and I didn't have a confirmed copy of it.
But you would have written your judgment?
Yes.
And you would have read it in court?
And read it in court,
yes. And you could have attached it here, so that we can assess your knowledge of criminal law, because as I understand it, it's not an area that you have practiced in before.
No. It was, as far as I recall, it was 90 pages of notes that I did read out. There's no reason why, I can't give a reason why I didn't.
I think I will leave it there. Thank you, Tisije.
Thank you, JP.
Thank you, JP. Premier, do you have questions for this candidate? Oh, there's a follow-up, Premier. Just give us a moment, JP Mlam.
Okay, all right.
Advocate Smart, good morning. Just one question. Have you ever attended such a aspirant judges training?
I did at the beginning of this year.
Were you present in the one Prof. Matenja was in?
Who? Sorry?
Prof. Matenja, the previous candidate.
No. I think he was in a previous one. I was in January this year.
Okay. Thank you, DCJ.
Thank you, JP. Premier?
No, thank you, TCJ. I'm okay, thank you.
Thank you.
Thank you, Ms. Ray.
DM, do you have questions for this candidate?
Thanks, yeah. Advocate Smart, I see you, from your CV, you were a small claims court commissioner from 2009, but only for 5 years.
Yes.
Why did you stop appearing in the small claims court?
Why did I start, or why did I
Stop.
Commissioner, I had moved out of Durban into an area which is sort of fairly semi-rural, and the travel and being at magistrates' court late at night, I was getting a bit concerned about that. So that was really the reason why we had tried. There was a discussion about small claims court being held earlier, but the vote was against that. So it was purely for safety reasons.
Okay, thanks. What other forms of community service do you do? You spoke about pro deo matters.
In the beginning.
Yeah.
I'm involved in the pro bono committee and have been for a few years. So just in terms of allocating pro bono matters, sometimes I take some pro bono matters myself. And I'm not sure, advocacy training. I lectured previously for the pupils.
Okay, because I was a bit concerned with the JP's, when the JP was questioning you, it's sort of not that detailed, but more what it reflects on, of not wanting to take up a case because you didn't want a part heard or another reserved judgment. And that doesn't reflect well on the users of the system, the parties in the case. So I'm looking for something to try and assure myself that you do see the public, the participants in a case, as very important and people who need to be to need to have their matters addressed.
I do believe that is very important, that there should be speedy justice. The reason I did not take on that second criminal trial is probably, that it is what it is. It was my first criminal session, and my concern was that it would run longer. It might have been more of an intrusion on, I didn't know what the future was holding at that stage.
Okay, thank you. No further questions.
Thank you, Commissioner.
Prof?
Thank you very much, DCJ. Good morning, Advocate Smart. I'm here. This side.
Good morning.
Yes.
Morning.
I want to take you to one of your judgments. Now my screen is just the one that dealt with it was an appeal from the magistrate court. I just want to take you to the relevant paginated page. I think it is paginated page 28 of your bundle. It is not clear on that page as to what the name of the parties are, the citation of the judgment, but it starts there nonetheless. And I want to take you in particular to, this was an appeal against conviction and sentence from the magistrate court for robbery with aggravating circumstances and murder.
Yes.
Yes, I want to take you to paragraph 25. It is on page 29 of that document. And I want to continue from where the JP ended when she said that she wanted to test your criminal law knowledge. I want to take it further and take it to criminal procedure and evidence. I'm not sure, are you there?
I am, the child witness.
Yes.
Yes.
And this is not your doing. I mean, in the trial court, the magistrate received evidence from 5 witnesses, one of whom is a 13-year-old. In your judgment, you say 13-year-old youth. I'm not really sure if you can refer to a 13-year-old as a youth, but besides that, what I'm concerned with is, because on their ground of appeal, what they are raising is the magistrate failed to assess whether the child understood the difference between telling the truth and not telling the truth.
Yes.
I'm not concerned with. I'm concerned with an issue that I don't think the representatives raised, and it doesn't appear as if the judges raised as well. This is the child witness. The Criminal Procedure Act, Section 170A, speaks about intermediaries.
Yes.
I'm not sure if, in this case, given the fact that this was a 13-year-old, was there no need to assess whether this child was suitable to testify? And if he or she was, then to testify through an intermediary? Or was it taken as a matter of course that he or she can just testify? In other words, what I'm asking you is, if you were to be confronted with a child witness, are you aware of the provisions of the intermediary and the facilities that can assist under these circumstances?
I am familiar. I wouldn't say I can recite it, but I do recall that in the case of child witnesses, intermediaries should be made available.
No,
And as far as I'm aware, they are.
No. Actually, in fairness to you, it's not should and it's not must. There are circumstances where they should be considered. What I'm trying to get to you, from you is, one, are you aware of that? And isn't it one of the things that perhaps maybe in your judgment could have criticized the trial court for?
I don't recall. As far as the intermediary is concerned, that's not dealt with in the
No, it's not dealt with it
No,
in the
yes.
appeal at all.
Yes, perhaps because the criticism was primarily on whether or not the child was properly admonished.
Yeah, but when looking at the case in totality, the issue of how the child gives evidence is critical. Because when you look at and you state that in your judgment, where the trial court questioned the child, do you know the difference between right and wrong? What is the color of what you are? That assessment is there. And there's a specific question that is asked there as to, if I were to say this to you, would you say that I'm wrong? And you can say that the child just answered differing from authority. So I'm just asking, if you were to be confronted with a child witness, would you consider an issue as to how the child should give evidence and the provisions of Section 170A, because they are there?
If I were hearing the trial and there is a child witness, or if
Yes.
yes, I think I would probably apply as many of the provisions that would protect the child giving evidence as possible.
Thank you very much, DCJ.
Thank you, Prof.
Can I just have a quick follow-up on that?
Yes.
Yeah, I mean, it's just something I've noticed on this issue. I mean, going back then to page 29, paragraph 10, well, this issue about admonishing the child witness, was the child witness a competent witness? And there's reference to section 163 and 164 of the Criminal Procedure Act, which is admittedly what the appellant had argued. But 163 and 164, 163 is about affirmation in lieu of an oath. It's not about trying to assess a child as to whether they can understand the truth or not. And 64 is when unsworn or unaffirmed evidence is admissible. So those sections don't appear to be quite relevant. I don't know if it was a mistake from the appellant in terms of the arguments that they put forward, but it's not about, as far as I can see, the section of the record that you quote here. It's about 163, affirmation in lieu of oath. There's nothing about children that I can see there. Did the witness take the oath? And if they didn't, did they affirm that they were going to tell the truth? I don't know if there was evidence that they took the oath or they didn't and therefore were affirmed, but I would have thought they would have taken the oath.
I think over the page is what occurred at the trial. I don't know whether that is in response, but...
Well, I'm saying what's over the page on page 30 is not relevant to those two sections of the Criminal Procedure Act.
Actually, I'm not able to respond to that. At that stage, I believe that section 163 and 164 were the relevant sections. It was a matter that was discussed with the other judge. I can't take that much further. Sorry, Commissioner.
I'm sorry, I didn't hear the last part of your response. What did you say about the other judge?
Well, yes, it was the appeal matter was discussed with the other judge. So I'm not sure, and not that I'm saying that there was anything incorrect about it, but my understanding was that that was the relevant section. I can't offhand say what that section is and whether it was relevant. My understanding is that it was.
Can I? No, Advocate Smart, I have difficulty with that because even though if your answer is, look, I cannot understand what happened at the time, that I can accept. But surely, because now it paints or it provides justification to the rumor that sometimes judges do not read the law. They just take what is in the head of argument and just put them in the judgment. That creates that impression, right? Because if a provision, the parties have referred to a provision, the first thing is to read the provision. And if somebody's arguing on the provision, is to try to get a copy of what is actually being argued. so that you can be able to determine for yourself that that provision is relevant or not. What would you say to that?
Commissioner, I do certainly ensure that I read the law before I do write the judgment. So I can't explain. I mean, it is something I do. I don't go straight out of the heads of argument and accept what is or is not there. It is something that I do research. So I don't know whether how to respond to that criticism.
No, thank you, DCJ.
Could I just follow up, DCJ? No, you see, Advocate Swart, sometimes an interview is a highly pressured sport. So have you actually confirmed that your judgment incorrectly cited the sections, or are you just going along because that's what is being put to you?
I have something that I looked at when I put included the judgment. I included judgments that I had written. There weren't very many that I could include, and I didn't go over them again and check that.
I'm saying, you see, because the question of the Deputy Minister is that you've cited a wrong section. You've confused a section that is about taking an oath with a section that's about ensuring that a child witness follows what's happening. So I just want to make sure factually whether you've compared that and satisfied yourself that actually you confused the sections.
I must have confused the sections then.
No, I mean, I'm not saying you have, but have you confirmed that you've confused the sections? I mean, before you admit to anything, because it's a terrible indictment to confuse sections for a judge, but I don't want to assume that you've done that unless you say, well, I've checked them. It's true that I've confused the sections.
I haven't checked them, certainly not since the judgment was written.
All right. Yes. There was something else I just wanted to put to you. I mean, which...
Is it still part of the following?
No, it's not a part of the following.
No, then you have to wait to 10, Commissioner. Had you finished? Sorry, who was it Prof? Had you finished? Okay. Pres Molemela.
Thank you very much. Good morning, Ms. Matt. Over here. Can you see me?
Right here next to me. Next to me.
Yes.
Yes.
Thank you, Commissioner.
I just want you to give me the assurance that you will cope with the workload if you are appointed. And I want to go back to the issue pertaining to the reserved judgments. And in particular, the judgment that was reserved in December 2022 and delivered only last week. Now, am I correct that your last acting stint was on the 15th, ended on the 15th of June 2023?
Yes.
All right. And between 28 October 2022 and 20 February 2023, you had 2 months within which you could have started that judgment.
Yes.
And then you went back, you acted for 5 weeks, and then you had another break, almost 2 months, because it's between March and May. And still, the judgment was not forthcoming. And your acting stint ended on the 15th of June. And between 15th of June and last week, if I'm not mistaken, is another 3 months. And eventually the judgment was only delivered last week.
Yes.
Now, the reason why I'm referring to these breaks is that normally the recess periods are used by the judges to write reserved judgments. And I'm worried that you know, since the date on which the judgment was reserved, you had several breaks but still failed to produce that judgment.
Yes.
And only managed to produce it about 10 months later. Now, remember, you've had these breaks in between, and if you are appointed, you'll be having less breaks.
Commissioner.
And you'll be in court every single day, presiding over cases and so forth. And so I really need you to, assure me that notwithstanding this aspect, you would be able to cope once you are appointed. And the reason why I'm a bit concerned is that this last delayed judgment is very, very recent. In other words, one is unable to say, well, there has been an improvement ever since, because it was only delivered last week.
Commissioner, yes, the breaks in between my acting stints, as I indicated, I had to go back to practice and catch up with stuff that had built up or with new matters. As far as this most recent judgment is concerned, it was a trial which ran into about 6 days, and there were, I think, 3 Liber Arch files of documents. It was something that was preying heavily on my mind. When I did start it, I think a couple of weeks ago, it was something that I was able to finish within a couple of weeks. So I do believe that, and as I said, you know, it's a lesson, it's a hard lesson that I've learned. I will be able to cope with the pressures.
Sorry, are you saying you only started writing it a few weeks ago?
A couple of weeks ago, yes. So once I'd started it, I excluded everything else from my life, and I was able to finish it.
All right, now, in these 2 periods, 20 February to 24 March and 15 May to 15 June, didn't you pick up any reserved judgments during those acting periods?
There was only that one, in February, there was that one reserved judgment.
And that one you wrote and handed it down before this one?
Yes, yes.
Why were you not in a position to prioritize this one since it was an older judgment?
I think because the unlawful arrest matter was less complex and less complicated than the other matter with the trial.
Thank you, Ms. Smart. Thank you, DCJ.
DCJ, can I just confirm something? Isn't it so that the last one, the Nene one, you probably prioritized it because I had written to you and I told you that the parties were requesting a judgment?
Well, I had been working on the judgment throughout.
Yeah.
Judge President, yes.
Thank you, DCJ.
Sorry, JB, did you say the parties wrote to ask
Yes, they
when
they
the
wrote-
judgment would be delivered?
Yes, and then that's when it was delivered.
All right, thank you.
Judge President, if I might just confirm that the judgment had been sent for to be handed down, I think, the day before, a few days before the email was sent to your registrar. So it did cross over. Yes, thank you. But I concede that there were requests.
Just one tiny aspect arising from your engagement with President Molemela. Did I hear you correctly to say that at the end of your acting stint, you still had a reserved judgment outstanding, and then you went back to practice and did not get time to write that judgment and deliver it because you had to catch up with your work in practice? Is that what you said?
Yes, yes.
So you put the judgment aside and took on new briefs and carried on with your work?
Yes.
Okay.
The reality of practice is bills have
we
to
know
be
the
paid.
reality of practice. I have your answer. Thanks, Ms. Mike.
Thank you.
Okay. JP Mlambo.
Thank you very much, TCJ. The question I want to pursue with you, Advocate Smart, is the issue about you. I think you've explained it, whether you refuse to take on a new criminal trial or not. You remember that part?
Yes, yes.
Raising it from a heads of course point of view that it is usually problematic for judges and acting judges when they are allocated matters to refuse to take them simply because they don't want to accumulate part head matters, because that has an effect on access to justice overall. Do you agree with me?
Yes, you know, in order to allocate a part-heard trial, when one is acting, it can only be allocated during recess periods. I do recall that the following recess period, when I had queried what the availability was for that next recess period, I think there were about 5 or 6 part-heard criminal trials which had been set down for that first week.
But you agree with me that it doesn't augur well for access to justice for judicial officers to refuse to take allocations simply because they don't want to accumulate part-heads?
That's not a good reason, no, absolutely. It was, as far as I'm aware, well, I do know for a fact that I haven't turned any other matters, you know, any matters that have been allocated to me, I have dealt with. It was only during that criminal stint that it might well have been as, because it was my first criminal stint and I wasn't that comfortable with criminal trials and I didn't know how I was going to be able to deal with them properly. I was probably a bit overwhelmed.
Okay. Thank you very much, DCJ.
Thank you, Commissioner.
Commissioner Kane?
Thank you, DCJ. Good morning, Ms. Swart.
Morning. Smart.
Smart.
Yes, thank you.
Thank you. Ms. Smart, I want to give you the opportunity to correct or improve upon an impression that arises from your application. And the impression is this, that you've had many years at the bar, you haven't applied for or taken silk as far as I understand. Your contribution to the bar and bar life seems to be pretty minimal. And the most significant matter that you list occurred some 8 matter in which you were led by senior counsel. So it leaves the impression that you haven't actually got a thriving practice or done all that much at the bar. And therefore there's this question mark about what meaningful contribution you would add to the bench. Why is it that the most significant matter occurred some 18 years ago when you were led? What have you done since then that would persuade us that this impression I'm putting to you is not correct?
Commissioner Kane, the reason I mentioned the GSK matter is purely because the application, my application was, I only came to realise that the closing date was on the 19th of June. I discovered that on the Saturday before that. So my application, I don't know how I missed that. It didn't seem that there were any notifications that came through on my email in any event. So my application was done in some haste. I could have had perhaps numerous other matters that I would have set down, but when I was going through the GlaxoSmithKline matter, it just suddenly occurred to me that that was one of the matters that I did thoroughly enjoy getting involved in, and also because it was a competition law matter, and I, you know, in KZN there are very few of those. There are matters that are of significance in the sense that, you know, various insolvency matters, other types of matters. I haven't applied for silk. My practice is such that I couldn't apply for, you know, it wouldn't have worked for me to apply for silk. Most of my briefing attorneys are small firms. I seldom used to get briefs, or I seldom get briefs from the so-called Big Five. So it's not, you know, I would have had to put if I applied for silk and was granted it, there was a real danger that my practice could have died.
Thanks, DCJ.
Thank you, Commissioner. Commissioner Case?
Thank you, DCJ. Good morning, Judge.
Morning, Commissioner.
Oh, advocate, sorry. In fact, I have two questions. One is a follow-up from the Judge President on criminal law. I want to ask you about sentencing. What is the discretion of the court, sentencing court, in circumstances where the sentence to be imposed is prescribed by legislation? That is
The minimum sentence.
yes. What is the discretion of the sentencing court, if any?
If there are exceptional, substantial and exceptional circumstances which would allow the court to deviate from the minimum sentence, and those exceptional circumstances are not circumstances which are frivolous or relating to usual kind of circumstances. They have to be truly exceptional.
Yeah. But what should be the starting point of the sentencing court? How the sentencing court should approach the matter in respect of minimum sentences?
Well, it depends on what evidence is led by the accused on sentencing.
Okay. Second and the last question. We are sitting in a trial, and it arises, you found that probabilities are evenly balanced in the sense that both witnesses, main witnesses for either side are equally credible or incredible. How you should determine the matter?
That's the Stellenbosch Farmers Winery case. You would then look at the probabilities of each version and look at the credibility of the witnesses, if they both have the same type of credibility, the demeanor of the witnesses. But when all of those are equal, it would be the probabilities of either version.
No, what I'm saying in this case, you have already passed that stage. You found that probabilities are the probabilities are evenly balanced in the sense that the plaintiff's version is credible, the defendant's version is credible. They are evenly balanced. Now, how the onus in that case would have been discharged?
That would depend on the plaintiff having the onus to prove. So, yes, sorry, I might have misunderstood your question. Is that what you were asking? So it's the onus would be on if the onus is on the plaintiff on that point, then the plaintiff wouldn't have discharged that onus.
Commissioner Nyambi?
Thank you, DCJ. Morning, Advocate Smart.
Morning, Commissioner.
The President Molemela covered the issue of the reserve judgment, so I'm not going to ask that question. There's one issue that JP asked you about, the referral the case that was referred to you that you refused to take. And JP Mlambo also asked you and you confirm what is expected of you. But I want to afford you an opportunity now sitting here in this commission in reflecting about that conduct. What is your position now?
Yeah, it was probably inexcusable. I think I was overwhelmed. I did discuss it with one of the other judges. I initially was going to, in that last week, take on the matter. And then when, I realized that the next available date would probably be much longer than if it goes back to the usual role. And I was led to believe by the DPP's office that that matter would probably commence in any event in November, as I recall. So it might well have been completed, as Commissioner Mlambo says, quicker if it had gone back to court for a new court to hear it.
My last one, if you consider what we have said to President Molemela about the delay judgment and that conduct, don't you think that advice of JP Mlambo in attending the aspirant women judges will go a long way to assist you so that we can be able to improve on that aspect?
I have attended that seminar. I enjoyed it very much, and I hope that I did receive quite a lot from that course.
Thanks, Advocate Smart. Thank you, DCJ.
Thank you, Commissioner.
Yeah, thank you, DCJ. Just one very quick question, Advocate. The environment, and in particular the issue of climate change, are topical issues, now. I see that you've done a postgraduate diploma in environmental law in 2003. Have you ever had to use any of this knowledge that you gained about the environment in a matter where you represented somebody or when you sat in court? Thanks.
Commissioner Singh, I don't know if you'll recall, but I think it was about that time, I was instructed by the state attorney. You were MEC for the environment at that stage, and the issue was relating to the casino licenses, and that was one of the times that I was involved in environmental law, in an environmental law matter. And another matter was also an instruction by the state attorney relating to the oil pipeline, also for the state attorney. But yes, so it unfortunately, unless you seem to be, I haven't received any further formal instructions in terms of that area, but I've been involved certainly on a kind of pro bono basis for various organizations in assisting in advising those in those matters.
Thank you very much. I had a vague recollection that you were engaged at that time in 2003. No, thank you very much. Thank you,
Thank you, Commissioner Singh.
Commissioner Bernard?
Thank you, DJ. Good afternoon, Advocate Mott.
Good afternoon.
Usually the procedural components of orders dealt with, towards the beginning of the order. For example, Rule 612, why the usual rules of procedure aren't useful for an urgent application and so on. So I was wondering, on page 62 in the Not versus RZT matter, it's paginated page 62 of the bundle, you seem to first deal with, let's call it part of the substantial matter that's before the court, and then only towards paragraph 6, which is almost the end of the order, you then grant condemnation for the late filing of an affidavit. So I was just wondering about the logical sequence of that order, whether that is, is that something you maybe want to comment?
Commissioner Barnard, that whole issue of condemnation was dealt with at the beginning of the judgment. So there were various applications for condemnation for late filing and etc. So right at the beginning of the argument, in fact, I asked from counsel whether we could just accept that condemnation be granted and that I would deal with the costs issue at the end of the judgment, and that is why the condemnation appears at the end of that order. It was part of the orders in respect of that.
Thank you. Thank you. Okay.
Commissioner Ngugaitod?
Thank you, Deputy Chief Justice. Advocate Smart, I want to come back to that discussion you had with Professor Marumo Ohaye and the Deputy Minister. The judgment itself from the bundle it starts at 28. But I just don't want to leave this under the impression that you've admitted that you confused the sections. The paragraph itself is at page 29, at paragraph 10. Do you have it?
At page 10.
Paragraph 10, page 29.
Yes. Sorry, that's line, sorry, is it line 10?
Yeah, paragraph
yes.
10.
Yes.
Yes.
Okay, yes, sorry.
You see what it says here? What you are doing there, you are not making a judgment. You are recording the submission by the appellant.
Yes.
And that's where, anyway, let me not lead you, but
Yes.
can you see what I'm trying to say?
Thank you. Thank you. Thank you, Commissioner. Yes, it does. The appellant contends that the court Akwa failed to apply the provisions of 163 and 164.
Yes, and then it continues.
Whether or not there was a proper differentiation between truth and falsehood.
Yes, so do you want to reconsider your response to the Deputy Minister?
If it would make a difference, yes, please, if I may. So it was the appellant's argument that section 163 and 164 were not applied. And then in this judgment...
Well, I mean, it was the appellant's argument. It seems to me that those sections related to the alleged failure of the presiding officer. Oh.
Let's just give it to
The judge confused the sections and applied the wrong sections because the judge did not understand that section 163 and 164 are not applicable in an instance of the competency of a child witness. And here it seems that what you were simply doing is to record what the appellant was saying.
Yes.
And if the appellant got the law wrong, that's not the fault of the judge.
Yes, thank you. Thank you, Commissioner.
Yeah, and then, but there is a bigger problem with the judgment, which has been pointed out by Professor Marumo, that structurally the judgment doesn't draw that distinction between the competency and the knowledge of truth and falsity. But that's not because you've misinterpreted or, in fact, misquoted a section. It simply seems that the judgment itself never articulates its own premise about, is this a judgment that criticizes the magistrate because the magistrate did not properly apply the law in relation to competency, or is it because the magistrate did not apply the law in relation to the ability of the witness to know the truth and falsity? So an adult witness does not have to be assessed through competency, but a child witness does. But both of them must speak the truth. And that's what seems to be unclear from the judgment.
Commissioner, paragraphs 12 and 13 of the judgment on the following page, page 31.
Yes.
Certainly paragraph 13. The comment is that it is apparent that the presiding officer failed to make the required determination. I don't know whether that is sufficient response to the concern.
Yes, the problem is I've seen that, in fact, it's the two paragraphs, 12 and 13.
Yes.
So the one is about speaking the truth, the other is about competency. The problem is the actual finding, I can't work out what facts were relied upon to come to that conclusion. But I mean, that's within the ballpark of a judge being wrong. It's not a howler than like citing section 162 and 163, which don't apply. That's the only point I'm making there. And then the second thing, also just to clear up, to make sure that we are not left with you remember you were asked by Commissioner Kane about your contribution to bar life. And I think even there you admitted that you don't really have much contribution. But there's a letter here from the AFT. This is what it says about your contribution to bar life. So I just want you to comment on that and see maybe you are selling yourself short. What they say is that at paragraph 17 of the letter from Jigela SC, she is the convener of the pro bono committee of the KZN Bar and has also done a lot of pro bono work in her personal capacity. She has contributed to the transformation at the KZN Bar and is the only white member of AFT at the KZN Bar. AFT KZN members reported that she assists junior members and has an open door policy. She takes black junior members in on matters and she is always available to assist. She provides accommodation for junior members and permits them to use her chambers when she is away on acting appointments. So it seems actually that you've got a much more substantive contribution within the structures of the bar.
Yes,
And
thank
that
you.
you are demonstrating your commitment to transformation.
Yes, thank you, Commissioner. Perhaps what Commissioner Kane might have been referring to, and my response to her related to the formal so-called bar council. My only contribution to being involved in the formal bar council is as the pro bono subcommittee. Other than that, I've never been asked to act on the so-called formal bar council. When I joined AFT, that was when I discovered that there was a lot more that I could do in terms of getting involved, not only in meetings, but also in bar life as such.
Thank you, Decision.
Thank you, Commissioner Nkoitol. At the risk of coming across as pedantic, following up on one of the aspects raised with you by Commissioner Nkoitobi about the reference to sections 163 and 164 of the Criminal Procedure Act, I am still not persuaded that the lifeline he threw at you saves you actually, because nowhere in your judgment do you point out that the reference to those provisions is erroneous, and you don't say anything about them at all. And one gets the distinct impression that you never went to look at them. The usual thing is that you would have said something about them.
Chair, just clarity which Commissioner Nkoitobi may have missed. I didn't say, I actually said when I read out the section, I assume this is what the appellant was arguing. But the issue still, as the chair says, is if I say in terms of section 163 and 164 that this wasn't done properly, I would have thought a response should have been for the judge to say that's not what 163 and 64 say. Arguing point.
Yeah.
Yeah.
You don't have to respond if you don't wish.
Well, I'm not sure really how to respond further than that. It's
No, that's fine.
something that's in the judgment, that isn't in the judgment, and I can't explain that.
All right, thank you. Commissioner Mwimang?
Thank you, DCJ. Good day, Advocate Smart.
Good afternoon, Commissioner. See you,
Just
yes.
just one aspect from my side in relation to page 14 of book 2 of 2, 6.2. The proportion of your litigation work in relation to constitutional law, you have indicated 0, which in essence says there is 0 exposure to constitutional law matters.
Well, I've never been instructed directly in a constitutional law matter, but where, I have an awareness of constitutional principles, obviously. And since I completed this form, I've been involved in a customary law marriage situation where the Constitution and the issue of Ubuntu is certainly going to loom large. So, but as far as direct briefs for constitutional matters to the Constitutional Court, I've not been involved that I recall. It hasn't been part of my practice.
But your grasp of transformative jurisprudence is fairly good.
It has, yes, it has become. I have quite a strong interest in reading, and the issue of Ubuntu and how, certainly in the last few weeks, I've found it quite enlightening.
Thank you, Advocate Smart. Thank you, DCJ.
Commissioner Matolo-Shepu.
Thank you, Deputy Chief Justice. Mine, Advocate Smart, is when Commissioner Kane asked you about why didn't you take silk, you said that taking silk would have killed your practice. And for me, it worried me in the sense that it seems that you are not getting enough briefs. I wanted to find out what is your type of practice under general, because you seem to be doing pro bono.
Yes, as I said, my clients, well, the instructions I usually get are from small firms. There are very few applicants at our bar, female applicants for silk, and those who are successful in their silk practice, other than the Annandales, etc., are those who do work for the state attorney. I haven't received, since my environmental law experience, I have not received any instructions from the state attorney, and I understand that is where most women's silks are able to maintain their silk practice. And I'm speaking generally.
Just a follow-up, have you ever raised it with the state attorney about instructions?
Every now and then, circulars sent out requesting the members to advise what type of work they have been getting from the state attorney, and each time I send the same response back, and I still haven't received any instructions. So, I mean, that's just something that has been quite literally since the early 2000s, when that was the only matters I did receive from the state attorney.
Okay, thank you. I will have gone further, but thank you.
Thank you, Commissioner Matolo-Shepu. We have reached the end of your interview, Ms. Smart. Thank you very much for making yourself available for the post. Unless you have anything to say to us, you're free to go.
Thank you. Thank you very much, Commissioners.